Ms. Cohen, you are a self-represented litigant. You're a trained paralegal. You filed a case in circuit court when you couldn't find a lawyer to represent you in a matter where you felt that you had been defamed. You've heard a lot said about self-represented litigants today. If you could tell us a bit about your experience, and I know that there was a certain level or a significant level of dissatisfaction, but as you go through it, if you could do it without making reference to the judge's name who's no longer on the bench, or the lawyers, since they're not here to make any comments.
Yes, sir.
Thank you.
Thank you, Mr. Sweeney, for having me here, and Baker Donelson, and I think what you guys are doing is really great. On behalf of all the pro se litigants who have been through this, we really appreciate it, really do. My husband and I decided to file a lawsuit after several attempts to file criminal charges because the police department insisted that our case was a civil matter. In January 2012, we met with an attorney and paid $500 for cease and desist letters to be sent to our potential defendants. When the problem continued, we began our search for legal representation. Several attorneys agreed that the case appeared to be a strong one and offered to take the case, even drawing up agreements. But the retainer fees ranged from $5,000 to $25,000 with the promise of running out long before trial. I was told that the cost would be an upward of $150,000 to get to trial. I was also warned that even though we would likely win a judgment, chances of seeing a penny of it were slim. We spoke to dozens of attorneys, and on 2 separate occasions we were offered contingency fee agreements, but in both cases the attorneys kept the case for nearly a month and then later dropped it for economic reasons. We never stopped looking for representation, but we decided that since I'm a paralegal and have a basic understanding of the court system, I would file the complaint on my own and do as much as possible. I did have a friend, attorney at Neil Harwell, can I say that?
Yeah.
Who unofficially reviewed most of the pleadings before I filed them, but essentially my husband and I were on our own. I spent a great deal of time on Westlaw looking into similar cases for guidance, not Judge Judy. 2 of 3 of our defendants were able to obtain attorneys. One of those attorneys, whom I shall not mention, and his assistant tried very hard to get us to drop the case. We refused because, among other reasons, our defendants had not subsided and were not taking the lawsuit seriously. In fact, filing the lawsuit seemed to only make them more hostile towards me, and they became very threatening towards me on more than one occasion. This is the reason I filed the motion to amend to add the more recent harassment counts to the complaint. I do not regret filing pro se because I feel that we were backed in a corner, so to speak, and it was all that we could do. It was important to my husband and I for us to stand up for ourselves against these malicious people, and since nobody else wanted to stand up for us, we did it on our own. I cannot deny that I felt belittled by the opposing counsel and the trial court judge. In the courtroom, the opposing counsel seemed to run circles around the judge, throwing rules and standards at him that didn't even exist. He was able to convince the judge to dismiss us on a Rule 11 and 45 violation because I had failed to provide copies of the subpoenas to him or his client, whom I was unable to even locate for several months, and because I had written a letter, disclaimer, I know better than this now, I had written a letter to the judge explaining my difficulty in obtaining representation. These were honest mistakes. I had no idea at the time that writing a letter was not acceptable, but I was in no way trying to influence him as the opposing counsel suggested. We were pro se, and I admit that I did make mistakes, but just as the Court of Appeals stated in their opinion, we couldn't understand how the trial court could use the strictest of sanctions by dismissing our case without considering our motion to amend. When our case was dismissed with prejudice, my defendants began to threaten to sue us for malicious prosecution. I could not believe that the court system would condone such malicious behavior and punish us for trying to hold them accountable. I was so upset that I began to have panic attacks. At this point, Attorney Joe Napoltonia took the case. Mr. Napoltonia filed a motion to alter or amend the trial court's order, raising the specific concern that the motion to amend was on the docket the same exact day as the motion to dismiss but had not been considered. However, the trial court denied this motion, saying it was without merit, still without offering an explanation as to why. I would have continued to trial pro se if I had to, although I certainly would have liked to have had representation. If it came down to it, though, I would have prepared myself the best that I could and gone toe-to-toe with the opposing counsel in the name of justice. I feel that the real monstrosity here is that the trial court showed favor to the attorney and didn't seem to care about justice or the truth. I believe that he just wanted to make my case go away, and he knew that as a pro se litigant, I couldn't do much to challenge his authority on this. It was a blatant disregard of our rights.
Okay, the Court of Appeals reversed the dismissal and reinstated the case. What do you think these various systematic methods of addressing access, like we've heard today, is there anything that you've heard or anything you've otherwise considered that could be done that would have eased this process for you as a self-represented litigant?
Absolutely. I think I wish that I had known about access to justice before I did this. Absolutely.